Welcome back. To other matters now, on the 7th of May, the Kano State House of Assembly passed into law the Pensions Rights of Speaker and Deputy Speaker Law Bill of 2019, which will enable the two presiding officers earn life pensions after leaving office. This kind of bill is being replicated in varying but similar formats by lawmakers across the country. Some legal practitioners who spoke to Law Weekly condemned the move and described the bill as self-serving.
The moment it is legislated upon and assent given to it by the governor of the respective states, it becomes legal. The question now is it moral? Morally, is it sound? And I will say no to that. It's not morally sound. Vis-a-vis the poverty in the land, as you said earlier, vis-a-vis the jumbo pay and allowances they've previously and currently allocated to themselves, I think it's irresponsible, I must say. It's irresponsible. The public can do something, but we are always aloof, feeling we are not affected or concerned. But at the end of the day, all of us bear the brunt. I think the civil society has a right to react to some of these things when they feel bad about it.
It is not right. It is even indecent, and it's extremely insensitive to the needs and aspirations of the people. We are living in a society where there's a lot of poverty. Now, there was a report, you might say it's political and all that Nigeria is a poverty capital of the world. But the underlying fact is that there's so much poverty in the land. So how do you explain giving public officers who have served for just a number of years life pension in the first case, when it's not a public service job or a civil salary job or a career job? And secondly, you pay them such huge amounts of money at the public expense or at the expense of what you call the national cake. I think it's most unfair. So it goes beyond legality. It goes to morality. It goes to even social justice and fairness. And I think some states have turned it down. I'm aware that Bayelsa, the governor, Seriaki Dixon, turned it down. And I believe any decent governor who has the wishes and aspirations of the people at heart will not assent to such law. And in the first case, any decent assembly in any part of the country will not even come up with such law. So I think it's most unfair and it's most unreasonable and very insensitive.
When I read about this on newspaper, I have put this across to some friends. Their reaction is just, I wish I could just it's a thing I can just bring forth here. Everybody reacting negatively to it and opposing the idea. You are just there on the temporal base. Serve and go. Other group will come in. If every group are coming and taking life pension, where are we going to? And we are already talking about the presidential system of government that is already taking much. Now, when this group go, other group are coming, is it not times the presidential system of government by 2 or by 3? It's not unfair. It's a way of trying to bring this country backward. Financially, we are not in the position to do that as a nation.
Let's now check out some of the top stories we tracked at the courts.
We begin with the report that Justice Condemn of the Federal High Court has declared as unlawful the defection of 53 lawmakers in the National Assembly to other political parties. Justice Abang held that based on the judgment of the Supreme Court, which laid down reasons that would allow for defection, the lawmakers did not meet that requirement. A legal defense assistance project, LEDUP, had filed the suit challenging the defection of the Senate President and 53 other lawmakers. LEDUP had asked the court to order the lawmakers to vacate their seats in the National Assembly and return all salaries and allowances earned since their defection, arguing that the lawmakers defected from their political parties for selfish reasons other than division in their parties as prescribed by law. But in the case of one of the lawmakers, Senator Godswill Akpabio, Justice Abang held that he is not in violation of the law because he neither decamped nor defected to the APC with the facts before the court. On Monday, the court granted leave to Senator Akpabio to file an application challenging the suit by LEDUP, saying that there is no evidence before the court that Senator Akpabio was personally served since the suit is not a class act against the Senate. According to Senator Akpabio, contrary to the suit filed by LEDUP, he did not defect to another political party but only moved. To election matters now, Hope Democratic Party has filed a motion seeking an order of the Presidential Election Tribunal restraining President Muhammadu Buhari from presenting himself to be sworn in on May 29, 2019. The party is also seeking an order restraining the Chief Justice of Nigeria from swearing in or administering the oath of office and oath of allegiance to the President on May 29th. Hope Democratic Party filed the motion on 6 grounds, one of which is that there is a pending petition challenging the election and return of President Buhari as the winner of the February 23 presidential election. The party also claims that in spite of the pendency of the legal action against President Buhari, he has been making frantic efforts and preparations for his inauguration on May 29. The party says that unless President Buhari is restrained from presenting himself for inauguration, he will file a fiat accompli and state of hopelessness on the court and render their petition null. The Hope Democratic Party therefore wants the tribunal to declare that once a question of the validity of an election of any person is challenged, that person is not competent to take oath of office or assume the seat of power. In another related matter, the Presidential Election Petitions Tribunal has adjourned till May the 22nd, when it will hear an application filed by the People's Democratic Party and its presidential candidate Atiku Abubakar. The petitioners want the President of the Court of Appeal, Justice Zainab Bulkachua, to recuse herself from the panel. The main opposition party said it is worrying that she decided to appoint herself the chairman of the panel, despite the fact that members of her family, especially her husband, are active members of the APC, which is a respondent in the suit. The party also says that it would be impossible to convince anyone that she's never discussed the petition throughout the trial with her husband, who is interested in its outcome. The candidate of the PDP, Atiku Abubakar, claimed that he won the presidential elections with 1.6 million more votes than President Buhari. At the Supreme Court, judgment on the appeal filed by the People's Democratic Party and its governorship candidate in Ekiti State, Kolakbo Olushola Eleka, challenging the election of Governor Kayode Fayemi, has been fixed for the 24th of May. The 5-man panel of the Apex Court, which heard the appeal, was led by Acting Chief Justice of Nigeria, Justice Tanko Muhammad. The appeal sought to overturn the concurrent judgments of the Ekiti State Election Petition Tribunal and the Abuja Division of the Court of Appeal, which both upheld Fayemi's election on the platform of the All Progressives Congress. In a related development, the same court also fixed May 24 for the judgment in their appeals relating to the dispute over the validity of the All Progressives Congress primary elections in Zamfara State, which produced the candidates fielded by the party in the last general elections. There had been 2 conflicting judgments of the Federal High Court in Abuja and the High Court of Zamfara on whether or not the party conducted valid primaries in the state. And we round up with the report that the Economic and Financial Crimes Commission, EFCC, has rearranged a dismissed judge of the Federal High Court, Justice Rita Ofili-Ajimogobia, on allegations of corruption. Justice Ofili-Ajimogobia was rearranged on an 18-count charge alongside a senior advocate of Nigeria, Godwin Obla. They both pleaded not guilty to the count, which border on unlawful enrichment, taking property unlawfully, corruption, forgery, and giving false information. Trial judge Justice Rilwan Aikawa admitted both defendants to bail on the same terms granted them at their previous arraignment. Counsel to the dismissed judge, Robert Clark, senior advocate of Nigeria, then informed the court of a preliminary objection he filed on the 13th of May, challenging the jurisdiction of the court. He said that the court lacked the powers to hear the charge, which according to him had already been decided by Justice Hakeem Oshodi of the Lagos High Court, Ikeja. Justice Aikawa has adjourned till the 23rd of May to hear the preliminary objection.
And that's our program this week. Thank you very much for watching. Be sure to catch the repeat on air or watch via our YouTube channel. I'm Shola Shieli. See you next week.